Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here.
Welcome to the deep dive. We're jumping straight into the intellectual property world today.
That's right.
We're looking at a really fundamental case, one that tries to draw the line between what a patent says and, well, what it actually protects.
Festo Corp v. Shoketsu, Kinzoku, Kogyo, Kabushiki Co., Ltd. A bit of a mouthful.
Definitely. It's a 2002 U.S. Supreme Court decision, and our mission today is to figure out how this ruling tackled a huge fight in patent law.
The core question being, how far can you protect your invention if a competitor makes what looks like just a tiny change?
Exactly. You've got this tension right.
Yeah.
Competitors need clarity. They need to know where the lines are drawn.
But inventors need fairness. You don't want someone to just tweak one small thing and completely avoid your patent.
It seems like a basic conflict.
It is, and for years, the legal world, especially the specialized patent courts, couldn't quite agree. It got to a point where the Federal Circuit Court imposed this really drastic rule, a complete bar.
Okay, complete bar. Sounds serious.
It was, and that forced the Supreme Court's hand. So today, we'll unpack the case, the lead-up, and this, well, compromise the court came up with.
All right, let's get into the specifics then. Who were the players?
The main parties were Festo Corporation, the patent holder, and the respondents, Shoketsu, Kinzoku, Kogyo, Kabushiki Co., Ltd., who are usually just called SMC.
Got it. And the case itself.
This was Festo Corp v. Shoketsu, Kinzoku, Kogyo, Kabushiki Co., Ltd., Supreme Court case number 00-1543. Argued in early 2002, decided May 28, 2002.
And the decision came from?
Justice Kennedy wrote the opinion for a unanimous court, which is pretty significant here.
Unanimous. Okay. Any notable lawyers involved, just for flavor?
Yeah, Robert Bork argued for Festo, Arthur Norstadt for SMC. The U.S. government also weighed in as an amicus curiae, a friend of the court.
So, high stakes. What was the actual invention at the heart of this?
It was about magnetic rodless cylinders. These are components used in, like, industrial automation, things needing precise movement.
You mentioned Disney World earlier.
Apparently so. Even Thunder Mountain, believe it or not. Festo had two key patents, the Stoll patent and the Carroll patent, covering improvements to this cylinder tech.
Okay, patents on cylinders.
Mm-hmm.
But the real issue came down to changes made after the initial applications, right? The amendment.
Exactly. This is crucial. Both patent applications ran into trouble with the Patent Office examiner and had to be amended. They were narrowed.
How so? What did they change?
Well, for the Stoll patent, it was amended after a rejection related to description requirements, Section 112 of the Patent Act, basically making the claims clearer.
So technical changes.
Yes. Festo specifically added limitations saying the device used a pair of one-way sealing rings and had a magnetizable outer sleeve.
And the Carroll patent.
That was amended during a later re-examination process, also to add that sealing rings limitation.
So in both cases, Festo voluntarily used narrower language to get the patents approved. They gave something up.
Precisely. They surrendered broader possibilities. And then along comes SMC.
With their competing product.
Right. And SMC's device was similar, but crucially different in ways that touched on those very amendments.
How different?
SMC's cylinder used one two-way sealing ring, not two one-way rings, and its sleeve was made of a non-magnetizable alloy.
Ah, so it didn't literally match the amended patent claims.
Exactly, which is why Festo couldn't sue for literal infringement. They had to rely on the doctrine of equivalence.
The idea that even if it's not identical, it's close enough, an insubstantial substitute, so it still infringes.
That was Festo's argument. They said SMC's changes were minor tweaks that didn't really change how the device worked.
How did that play out in the lower courts?
Initially, the district court agreed with Festo, found infringement under the doctrine of equivalence.
But then it went up to the Federal Circuit, this specialized patent appeals court.
Yes. And on remand, the Federal Circuit didn't just disagree, they laid down a whole new, very strict rule, this complete bar we mentioned.
Okay, let's dig into that. The complete bar and this idea of prosecution history, estoppel, what's the core legal fight here?
Right. Prosecution history estoppel is the basic principle. If you give up subject matter during patent prosecution, usually by narrowing your claims to convince the examiner, you can't later use the doctrine of equivalence to recapture what you gave up.
Makes sense. You can't have it both ways.
But the huge questions the Supreme Court had to tackle were about the scope and the degree of this estoppel.
Okay, break those down. Scope first.
The scope question was, does this estoppel only kick in if you made the amendment to avoid prior art, meaning older inventions that would have invalidated your broader claim? Or does it apply to any narrowing amendment made for any substantial reason related to getting the patent, like Festo's amendments to meet those description requirements under Section 112?
So does the reason for the amendment matter?
That was the first big question. The second was about the degree of estoppel.
How much territory do you lose?
Exactly. If estoppel does apply, is it a complete bar, as the Federal Circuit ruled? Meaning you lose all possible equivalents related to that amended element? Absolutely everything.
Oh, that sounds harsh.
Extremely harsh. Or is it a more traditional flexible bar where courts look at what was actually surrendered during the amendment process? A more nuanced approach.
Okay, so those were the two forks in the road for the Supreme Court. How did Festo argue their case?
Well, Festo obviously hated the complete bar. They argued first that their amendments weren't made to avoid prior art. They were just clarifying things, meeting technical requirements.
So they argued those kinds of amendments shouldn't trigger estoppel at all.
Right. They claimed they weren't consciously surrendering inventive concepts, just refining the language.
And their backup argument.
If estoppel did apply, it absolutely had to be the older, flexible bar. They argued the complete bar was a radical departure that would destroy the value of countless existing patents whose owners had relied on the flexible approach when amending.
It sounds like they were arguing it would pull the rug out from under inventors.
That was a big part of it, the unfairness to existing patent holders.
What about SMC, the defendant? What was their counter?
SMC focused on certainty and the public notice function of patents. Their argument was pretty straightforward. Festo chose specific words. Magnetizable sleeve. Pair of one-way sealing rings.
They chose to narrow the claims.
Yes, to get the patents granted. SMC said, by making that choice, Festo surrendered everything outside those specific words, including, well, non-magnetizable sleeves and single two-way rings.
Regardless of why they made the amendment.
Correct. SMC argued the reason didn't matter. The act of narrowing the claim created the estoppel, and Festo should be stuck with the literal words they ended up with. They surrendered the territory where SMC's device lived.
So it really comes down to this fundamental tension. Certainty for the public versus fairness for the inventor. How did the Supreme Court resolve this?
They tried to find a balance. It's why the decision is so studied. They actually vacated the Federal Circuit's ruling. They threw out the complete bar.
Okay, so good news for Festo on that front.
Yes, but they actually agreed with the Federal Circuit on the first question, the scope.
Wait, really? So any narrowing amendment triggers estoppel, even just for clarity?
That's what the court held, unanimously. They reasoned that if you amend a claim to overcome any patentability rejection, you are conceding that the original broader claim was flawed.
Even if it wasn't about prior art?
Even then, failing to appeal the examiner's rejection and instead choosing to amend is seen as a concession. You narrate it for a reason related to patentability, so estoppel applies.
So Festo lost on the scope issue,
No.
but they won on the degree. The court rejected the complete bar.
Correct. The court flatly rejected the complete bar. Justice Kennedy wrote that it went too far, that it undermined the entire purpose of the doctrine of equivalence.
Which was designed to prevent exactly this kind of rigid literalism.
Precisely. The court acknowledged that language isn't perfect. An inventor might amend a claim and still not be able to foresee every possible future variation or equivalent. A complete bar would unfairly punish inventors for the limitations of language and foresight.
So if it's not a complete bar, and it's not quite the old flexible bar,
Right.
what do they put in its place?
This is the core of the Festo decision. They established a rebuttable presumption.
A rebuttable presumption.
Meaning, when a patentee narrows a claim for a reason related to patentability, the law presumes they surrendered all equivalents for that narrowed element.
Okay, so the starting point is you gave it up.
Yes. But, and this is the key difference from the complete bar, the patentee gets a chance to rebut that presumption, to prove they didn't surrender the specific equivalent the competitor is using.
So the door isn't completely shut.
Yeah.
But it sounds like the burden of proof is now squarely on the patent holder.
Absolutely. It's a heavy burden. The patentee has to demonstrate that the amendment doesn't actually cover the equivalent in question.
How can they do that? What kind of proof works?
The court laid out a few ways. The main one is showing the equivalent was unforeseeable at the time of the amendment.
Unforeseeable. Like the technology literally didn't exist yet.
That's one possibility, yes. Or perhaps its application in this context wasn't conceivable. Another way is to show the rationale for the amendment was only tangentially related to the equivalent.
Meaning the reason you amended had almost nothing to do with the specific difference the competitor is using.
Sort of, yes. Like the amendment was aimed at fixing one specific problem, and the competitor's equivalent relates to a completely different aspect. And the court also left a little wiggle room, mentioning some other reason, suggesting the patentee couldn't have reasonably been expected to claim the equivalent.
Okay, let's connect that back to Festo's specific situation. They amended to require a magnetizable sleeve. SMMC used a non-magnetizable one.
Right. So under this new rule, the presumption is that Festo surrendered non-magnetizable sleeves.
And Festo would have to prove, what? That a non-magnetizable alloy functioning equivalently was somehow unforeseeable back when they made the amendment.
Essentially, yes. Or that their reason for adding magnetizable was only tangentially related to the property of magnetism itself, which seems unlikely. It puts the inventor in a tough spot.
It really does. You almost have to predict the future of technology.
That's the criticism.
Yeah.
It preserves the doctrine of equivalence in theory, makes it very hard to use in practice once you've amended a claim.
So this wasn't decided in isolation. You mentioned the Warner-Jenkinson case from 1997. How did Festo build on that?
Warner-Jenkinson kind of set the stage. It confirmed the doctrine of equivalence was still good law, but also strengthened Estoppel, saying it applied for any substantial reason related to patentability.
Okay.
Festo took that phrase, substantial reason, and basically defined it to include everything prior art, Section 112 description issues, anything that led to narrowing the claim to get it allowed. It slammed the door on arguing that only prior art amendments triggered Estoppel.
Got it. And the fact the Supreme Court was unanimous here, especially after the lower court was divided. What does that tell us?
It's huge. It shows a strong consensus on rejecting the Federal Circuit's extreme complete bar. The justices agreed that went too far and would disrupt the patent system.
But they also agreed that estoppel needed to be broad.
Yes. They found common ground. Amendments matter. They limit scope broadly, but not absolutely. The rebuttable presumption was their compromise.
So what's the lasting impact? The legal significance for people dealing with patents today?
It fundamentally changed the calculus for amending claims. It restored a version of the flexible bar, but weighted heavily against the patentee. Predictability increased for competitors they know an amendment creates a strong presumption of surrender.
And for inventors and their lawyers.
The practical advice became, amend claims as little as possible. Avoid narrowing if you can. Because if you do, proving unforeseeability or tangentialness later in court is really, really difficult. That presumption is tough to overcome.
So if we had to boil it down to one key takeaway from Festo for our listeners.
I'd say it's this. Narrowing a patent claim during prosecution always costs you something. It creates a strong legal presumption that you've given up equivalence, and reclaiming that territory later is an uphill battle. Precision matters up front.
So the words you choose when you narrow that claim are incredibly important. But the court acknowledged they can't always capture every future possibility.
Right. The Festo ruling means the written word is critical, but there's this tiny escape hatch, the rebuttal for truly unforeseen circumstances.
And it's important to remember the Supreme Court didn't actually decide if Festo itself could rebut the presumption, did they?
No, they didn't. They set the new legal standard, the rebuttable presumption, and sent the case back down to the lower courts. Festo still had to try and prove its case under this new, tougher framework. Whether the non-magnetizable sleeve was truly unforeseeable was left for another day.
Which leaves us with a really interesting final thought, doesn't it? Imagine an inventor amends a claim today, specifying material X. 20 years later, a competitor comes up with material Y, a perfect substitute, using nanotechnology that simply didn't exist when the patent was filed. Should the law protect the inventor who couldn't possibly have foreseen material Y? Or should it favor the competitor relying on the specific words material X? Where do you draw that line between foresight and fairness?
That's exactly the challenge Festo poses for courts every day in these kinds of infringement cases. It's a constant balancing act.
A fascinating dive into a really complex area. Thank you for walking us through that.
My pleasure.
And thank you for joining us on this deep dive into prosecution history, Estoppel, and the legacy of Festo.